God, Lally just looks defeated already. Look at him. He doesn't want to be there. Look at him.
Oh, we're good. That's a little better.
Where's sound? We got no sound.
The sound is terrible.
There's nothing. I don't hear anything.
It's better.
You get the volume up, Eden?
Yep.
Everybody's asking, where's the sound? Where's the sound? No sound. No one can hear it, Aiden.
No one can hear it? Oh, okay.
Yeah.
I can hear it.
Muted. Everybody said no sound.
So today,
There you go.
I changed some of the dates to accommodate you. I think there was some short trial dates. You
Oh,
restitution
because
dates, and so
You got a
to get
banner
the
hanging
order
too,
on the
Aiden.
dates.
All right.
So today is only for filing all Rule 17 motions and for the motion to dismiss under Odell and the motion for sanctions.
Hold on.
So,
you guys hear two
I
things?
don't remember if it was
No.
Mr. Jackson.
We got another
or Mr.
window pulled
Yannetti
up
who
probably.
Last time
Yeah, I gotta
said
find
that
it.
I was
Just
operating
mute
from
it.
a blind spot because I didn't have the information that was disclosed to you folks from the U.S. Attorney's Office. So you were good enough to get me the entire packet, which I appreciate. I read it. I see now how the federal investigation began and when it began.
Interesting.
I've also read the pleading. So the motion to dismiss, defendant's motion to dismiss is around 50 pages with attachments. The supplement is about 15 pages. The Commonwealth's opposition is about the same. The motion for sanctions is about 30 pages. There's no supplement, Mr. Yannetti?
There's no supplement.
Okay, and then the Commonwealth had about 25 pages, and then the Commonwealth supplement covered both motions, and the Commonwealth
Gone.
had originally probably hundreds of pages of
about
exhibits.
that?
So I have read all of that, and I am mindful also. I keep coming back to the letter that was written to me on February 26th from the Deputy U.S. Attorney, who says, "We expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings." So I've read everything. I'm going to give each side 10 minutes, and we're going to start with the motion to dismiss.
Okay.
So, Mr. Jackson, I'll hear you. I think it would be particularly helpful if you were to focus on the exact prejudice to the defendant and how this all goes to the core of the Odell motion. And as you know, that's an awfully high bar. So go ahead.
Yeah, which you gave them no time to prepare for.
Your Honor, I will try to edit my comments to stay within the 10-minute mark. It's very difficult to do that. I did not know that we were going to be under such incredible time constraints. As a matter of fact, I thought that the court said the last time we were in court, we had basically your words.
Yeah,
we had
all day. But that was when we had all the motions, but it's just these two motions.
Give them-
today.
But they're big.
They're big.
She's so shady.
So
consistent with
why don't you go ahead and start? If you need additional time, tell me. But it would be important to focus your argument. Again, I'm mindful of what the U.S. Attorney said to me in that letter.
and I am as well. And that mindfulness suggests that my comments will be directed to that which is necessary to further the proceedings.
Okay,
Which
go
means that
right ahead.
I'll start with the basic rule.
Means
of
I need more
Odell.
time.
Yeah.
We start with the postulate that any distortion of the evidence, that's where we start. Any distortion of the evidence during the course of a grand jury proceeding impairs the integrity of the indictment, if there is an indictment, and pursuant to Odell, that requires dismissal. In this particular case, there were myriad examples, which I will, again, I'll edit. I was going to go through several, but I'll just touch on them very
Yeah,
quickly.
your memo, I have to say, your memo is very thorough and very helpful to me because you outline everything and same in your supplement.
Thank you.
Oh,
The
that's
first one I
sweet.
want to discuss is what we believe is the failure to disclose Sergeant Michael Lanks' personal, lifelong relationship with some of the individuals,
told you he was
specifically the
involved.
There
individual
it is.
Chris Albert. There was a comment or an incident, I should say,
On Turtle
that we referred to in our movie
Sandra
papers
Birchmore.
that dealt with Chris Albert and Sergeant Lank years ago.
And a lot
They had
of
a long-standing, years-long relationship. And I'll close this loop in just a second, but if you'll allow me, that relationship goes all the
shit.
way back to 2002 at least. And there was an incident in which Sergeant Lank and Chris Albert had gotten into what can easily be described as a bar fight. Chris Albert had gotten into a bar fight of some
What?
sort.
Got a report
Michael
of
Lank
the
walks out
Lafayette
of
brothers.
the same bar or an adjacent bar.
Lank
He'd been
was
drinking
off
with his buddy
duty.
Chris. He walks out, stumbles out,
Listen to this.
announces to the participants in this fight that he was quote unquote deputizing himself, and ultimately came to Chris Albert's aid. That was with the specific intent to assist an Albert in getting out of a legal jam all the way back to 2002. The reason I bring that up, and by the way, both of the individuals involved, not Sergeant Lank, both of the other individuals involved were ultimately arrested by Sergeant Lank. That case went to trial, and both of the individuals were found not guilty of assault. And that's after Michael Lank engaged in fisticuffs with at least one of the men, to the degree that the Canton police officers had to pull him off of the individual.
So this is in your memo, and it also is exhibits C through E
That's
attached
right.
to your memo.
And the reason this comes to a head and the conflict of interest comes to a head is because Michael Lank ultimately was the first person to walk into Brian Albert's house. During the course of the grand jury, nobody elicited information from Michael Lank that he had a close personal relationship with the Alberts, that he had in years past come to the Alberts' aid. And yet he was the first person that came into the house. Even the grand jurors were stunned by this and asked, the specific grand jurors asked Michael Lank and asked the Commonwealth, or through the Commonwealth of the witness, why didn't Brian Albert ever even come out of the house? And I think we have the answer. And the answer is because the Albert, specifically Brian Albert, was waiting on a friendly. And they got that friendly through Michael Lank. That was withheld from the grand jury. Sergeant Lank is a longtime childhood friend of the Alberts. The Canton Police Department was conflicted off the case because of those personal and familial relationships that the Alberts have with Canton Police Department. And Sergeant Lank has a history of using his position as a police officer to shield the Alberts from criminal liability.
Get
That was
him.
never brought out. That's the kind of distortion that Odell talks about. Another broad example or a broad category that I want to discuss briefly deals with Trooper Michael Proctor. The Commonwealth withheld from the grand jury clear and even more egregious conflicts of interest as they pertain to Michael Proctor. Sergeant Lank was aware of this irremediable conflict that Canton Police Department had and that he should have had with the Alberts. So what does he do? He calls in Massachusetts State Police. And who do they send but Michael Proctor? And that's like jumping from the frying pan into the fire. That's the same Michael Proctor who's also years-long close family friends with the Alberts. The Proctors have called the Alberts their, quote, second family. And to that point, now we have benefit of some hindsight, and that's the federal investigation. We have been saying since September 16th, 2022, in lengthy motions that we filed before this court and filed with the Commonwealth, there is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors. And we've been rebuffed at every single turn. Newly uncovered text messages, but from the feds, revealed that on January 19th, 2022, think about that date, that's 10 days before the incident. January 19th, 2022, Michael Proctor texted his own family members discussing the specifics of having Julie Albert babysit for his toddler child.
Wow.
We should all let that sink in for a second.
So yeah, I understand that.
There is a level of closeness that cannot be overstated. Michael Proctor is so connected to the Alberts that he was entrusting them or willing to entrust the Alberts to be caregivers for his toddler child. And it's not lost on anybody in this courtroom that for 2 years, the Commonwealth has been denying it and still denies it in their opposition paperwork. They still say, well, there's nothing to see here. It's Michael Proctor's sister who really is friends with Julie Albert, and that, that's not a big deal. Everybody looked the other way. As a matter of fact, Ms. McLaughlin wrote the following in her opposition. Trooper Proctor's supposed close and personal relationship with the Alberts is, quote, entirely unfounded and a desperate creation of the defense, a desperate creation of ours. She says we created this. But now we have the benefit of the federal investigation. And the
Receipts.
Commonwealth finds itself in that very unenviable position of having to eat some very distasteful words, because we didn't create anything. And there's more. On February 1st, 2022, 3 days after John O'Keefe was killed, there was another text message. In this one, Michael Proctor's sister texts Michael Proctor very specifically and writes the following, quote, just saw Julie, and Julie said when all this is over, she wants to give you, Michael Proctor, a thank you gift. Michael Proctor didn't respond with, that's inappropriate, these are witnesses, these are potential suspects, please tell her don't ever do that again, don't ever suggest an exchange of gifts again, that would be inappropriate. I'm going to go write a report. I'm going to turn it over to Mr. Lally, and Mr. Lally's going to turn that information over to the defense and to the court. No, that's what he should have done. What he did do is he responded, get Elizabeth one, his wife.
Wow,
In other words, get the
dude.
gift from my wife. It'll be a little less obvious. So now we have the lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on the one hand and the Proctor family on the other hand as a thank you, their words, for helping the Alberts out of a jam. And if you looked up quid pro quo in the dictionary, you would find this set of text messages. 2 years later, to the day, on February 1st, 2024, now let's fast forward 2 years later, now Michael Proctor finds himself on the witness stand in front of a federal grand jury, which we just found out about. That grand jury was tasked with a singular commission, and that was investigating crimes of public corruption by law enforcement in relation to this case. And during that testimony, he was confronted with these and myriad other examples of evidence of his close ties to the Albert family. And he admitted to an AUSA under very intense questioning that not only does he know the Alberts, and does he socialize with them, does he drink with them, does he go to pool parties with them, but he told his partner, Yuri Butnick, all of this before Yuri Butnick testified at the grand jury and before he and Butnick actually interviewed Chris Albert. Why does that mean something? Why does that mean something to the court and to this argument? Because when Yuri Butnick testified before the state court grand jury, he testified that, quote, following formal introductions, end quote, Julie Albert and Chris Albert provided their phone numbers. Following formal introductions. That was a clear deceit on the grand jurors. Yuri Butnick knew, as did Michael Proctor, they didn't need formal introductions. Michael Proctor was considering having Julie Albert babysit his kid 10 days ago. Actually, at that time, 13 days ago. That left the grand jury with the intentional false impression that these people literally do not know each other. They've never been in contact. They're complete strangers. That was a lie. That was a concerted effort to hide that relationship and to hide the conflict of interest. And the grand jurors were fooled. They were left with the impression, Michael Proctor, Yuri Butnick, they don't know these folks. They're completely neutral, independent investigators, and nothing could be further from the truth. And the revelation of this evidence culminated in front of that same grand jury on February 1st, 2024. Under additional intense questioning by the Assistant United States Attorney, Proctor was caught in his own web of deceit and testified as follows, quote, this is the AUSA talking, or asking the question. So obviously we're asking questions about your relationship with Julie Albert, with Chris Albert, and with Colin Albert. Do you understand that? Answer, yes, sir. Question, and you're saying that you're minimizing, quote, minimizing your relationship to the grand jury, correct? Answer, yes. He finally, under the scrutiny of a federal grand jury, admitted that he had been lying about his relationship to the Alberts, which means he lied to the grand jury, which means that evidence was distorted in front of the grand jury. And that is the burden that Odell requires.
All right.
Wow.
So your time is up, which includes me interjecting. Do you want 5 more minutes?
Yes.
If I could
Yeah.
implore the court.
I'd like you to sort of get to the questions I asked
This
as well.
lady, dude.
All right. I know you're reciting the evidence that I've read, but so I'll give you 5 more minutes. Go ahead.
Thank you. I want to shift gears to
You hear her
another
language?
example or another series of examples of evidence that was distorted before the grand jury. And that deals with the use of or the insinuation of Kevin Albert, yet another Albert, at the behest of Michael Proctor. Kevin Albert is a sworn Canton police officer. On day one, the Canton Police Department was completely recused off the case, in no small part because of Kevin Albert and the fact that John O'Keefe's body was found on Kevin Albert's brother's lawn. Yet the evidence that has been disclosed by the federal investigation, which we were not privy to, is that Michael Proctor actually utilized Kevin Albert's services to coordinate with the very witnesses who should have been potentially suspects and certainly should not have been subject to coordination by an Albert, when that's the very person on whose lawn John O'Keefe, or his brother's lawn, John O'Keefe was found. I want to turn to at least one more situation
Okay.
in my remaining minute or so, given the fact that this is curtailed. And this is not in our papers, but obviously it's a complete and probably the most obvious distortion of the facts. The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case, and that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold. They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Celebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence. They claim, oh, well, we didn't have the right version of the Celebrite software. That's on them. That's not our fault. Certainly not Mr. Reed's fault. That's their fault. Get the right software. If you're going to bring this case, do it the right way.
Right.
They say their argument is, well, we just didn't have the right software, so we didn't have the information. That's not true.
Yeah.
They did have the information. It was sitting in her phone. They just didn't do their job in extracting.
Jackson.
And should the Commonwealth once again stand up in some sort of desperate pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Celebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI's Regional Computer Forensic Lab. In other words, the United States Federal Bureau of Investigation also specifically confirms that that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 and 40 seconds a.m. on January 29th, 2022. That fact, Your Honor, is no longer open for debate.
That's why she's not there.
Woo!
That's why
The
she's not
feds
there.
confirmed
None
it.
of that was presented before the grand jury.
The feds confirmed it.
I'll conclude by
Yes!
saying any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion from the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation before by the Commonwealth before the grand jury and the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Ms. Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust, the ones that are supposed to protect our interests. And the law does not allow this sort of conduct to go unchecked. When the remedy, when this sort of travesty of justice occurs, is established by this state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety. And it is not enough, and I'll be surprised if I don't hear it today, but something suggests, based on the moving papers that we just got from Ms. McLaughlin and Mr. Lally, are Well, Your Honor, we didn't know. We didn't know about the text messages. We didn't know about Proctor. We didn't know about Lank. All that stuff was revealed through the federal grand jury. It doesn't matter that Ms. McLaughlin individually didn't know, or Mr. Lally can say, I claim ignorance. I didn't know either. It's enough that an arm of their institution, law enforcement, they knew. And that was their job to tell the truth. That was their job not to fool or distort the Commonwealth. I'm sorry, the grand jurors. With that, Your Honor, thank you for the time, and I'll submit.
All right, thank you. Mr. Lally, we're going to start with 10 minutes. If you need more, you need to tell me.
Good luck, Lally. Good luck, Lally.
Wow.
Good
I
luck,
mean,
Lally.
This is insane. The feds
Peter-
confirmed the 227 search.
Yeah.
The
And
feds
thank you, Your Honor.
confirmed
No,
that they
I
did
think
their
10
own
minutes should be
independent
fine.
investigating
Just,
of it.
I know the court has taken painstaking detail to go through all the material that's submitted, so I'll be as
Karen's
brief as I
smiling.
can. Essentially, the defendant, as the court is aware, doesn't challenge the grand jury presentation on the McCarthy grounds or probable cause standard. Defendant motions challenges under Odell. Odell essentially states dismissal of an indictment on impairment of the grand jury proceedings requires proof of three elements, as the court is well aware. One, that the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. Secondly, that the evidence was presented for the purpose of obtaining an indictment. And three, that the evidence probably influenced the grand jury's decision to indict. None of which I would submit the defendant has met their burden with reference to any of those three elements. Just addressing sort of the overarching themes of the defendant's motion. The defendant challenges, as he just stated, the testimony of Canton Police Sergeant Lank and his testimony attributing statements to the defendant that were made in the aftermath of Mr. O'Keefe's body being discovered in a purported deception of Sergeant Lank's relationship with the Albert family. Trooper Proctor's purported false and deceptive statements throughout the course of his testimony, and the Commonwealth's failure to elicit a purported inconsistent statement of Christopher Albert, and the Commonwealth's failure to impeach Julie Albert's testimony. Your Honor, simply put, none of these issues or stated malfeasance actually occurred before this grand jury. As it relates to Sergeant Lank, I mean, we're talking about what the defendant submits as an attachment is an incident from almost 20 years ago, which doesn't involve anyone who was at the house at 34 Fairview Road on the night when Mr. O'Keefe died. The statements that Sergeant Lank is attributing to the defendant were not only testified to by Sergeant Lank, and they're testified not in a deceptive manner. They're testified to by Sergeant Lank in the sense of he indicated he spoke to officers who had preceded his arrival. All of those officers also testified before the grand jury. All of those members who received statements from the defendant essentially indicating that she did it, that doesn't just come from one source. That comes from at least 5 different witnesses, 3 of them paramedics with the Canton Fire Department. Counsel posits the question of why didn't Brian Albert come out of the house? No one did. Not only out of that house, but any house. It's clearly visible in the grand jury exhibits. You have the cruiser camera footage from Officer Saraf, as far as no one else in the neighborhood coming out of the house, as well as testimony from a number of different witnesses that were there and present on that morning in the dark, in a blizzard at the time that Mr. O'Keefe is found. Counsel wants to say that the Commonwealth is asking the court or everybody to sort of look the other way when it comes to these things. What I would submit is that's exactly what the defendant is doing. Look the other way, defense by obfuscation. It's essentially, it's a 3-card money trick, card trick on the corner on the side. Look at all of this, look at this relationship, look at that relationship, conflating these relationships, sort of the distortion that I would say between what exists in social media realm and what exists in reality. That if you know someone, that automatically means that you're best friends with them, every single one of their siblings, every single person that they've ever met or socialized with. One social interaction, transforms into a long-standing 20-year relationship, all of those things. And what the defense is obfuscating from is the overwhelming evidence that was presented to this grand jury from a multitude of sources, 42 separate witnesses, 56 exhibits, over 1,400 pages of transcripts, which clearly demonstrate and indicate that the defendant, Karen Reed, killed John O'Keefe.
You don't?
But they don't want you to look at that. They want you to look at who texted who when and what they said and what was asked and what was promised. In reviewing the materials provided by the U.S. Attorney's Office, a couple things that I would note is, number one, they have no idea how much of a percentage of the totality of the federal materials we have. I don't know if we have 5%, 50%, 90%. I have no idea. The other part that's confounding is that it appears that these materials or materials from the state prosecution were provided to the U.S. Attorney's Office by Mr. Yannetti or by the defendant or by defense counsel. And again, what I don't know is how much of a percentage of the total discovery from the state case was actually given and provided to the U.S. Attorney's Office in which to conduct their investigation. But it's clear from the investigation that they extensively investigated the facts and circumstances that led to Mr. O'Keefe's death. In sum, what I would submit, just as Ms. McLaughlin stated on the last date, that these materials are largely consistent with the Commonwealth's theory of the case. There is no suggestion of a third-party culprit, no suggestion of cover-up of evidence, no suggestion from the 13 civilians' witnesses' testimony that we've received, or transcripts of that testimony. All of them confirm that Mr. O'Keefe never entered 34 Fairview Road. All of it was absolutely no animosity between the individuals at the Waterfall Bar or at 34 Fairview residence. There was no fight. There was no dog attack. There was no eyewitness to the circumstances that led to Mr. O'Keefe's death. Witnesses also testified consistent. A year later, they testified in the state grand jury in the spring of 2022, largely in the spring of 2022, and then largely in the spring of 2023 before the federal grand jury. And their testimonies are largely consistent with the defendants making declarative statements that she did it, not a question mark at the end, but clear definitive statements on scene, that she had discussed the damage to her taillight prior to leaving Mr. O'Keefe's home on the morning of January 29th. You have a number of different statements that were alluded to by Mr. Jackson in regard to texts between from Trooper Proctor's phone. Of note, there are no text messages between Trooper Proctor's phone and Julie Albert's phone, except for two no-content text messages, one from June 21st, 2020, and one from September 1st of 2020. There is a discussion between Trooper Proctor and his sister because Julie Albert had provided childcare in a pinch on several occasions for Trooper Proctor's sister. Trooper Proctor also testified that Julie Albert never did that for him, never watched his kids, never had looked after his children. That essentially never happened. Lastly, get to the Google search, and
Okay, this
I
will
would
be
agree
good.
with counsel in the sense that it's really no longer open for debate. But I'm not really sure why we're still even talking about this or why this is still a topic that they're pushing.
He sounds like
Essentially, what we
Plevin.
have is, yes, what counsel
Yeah.
mentions is there is one expert who was given two extractions, presumably provided by defense counsel, that indicates from that particular FBI expert that the searches were done at 2-something in the morning. What counsel neglects to sort of raise and stress with the court is that there's a separate, and I forget exactly what it stands for, but an RCFL analysis of the phone in which through both Axiom and through Celebrite, and that conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred because the defendant asked her to conduct those searches at 6:23 and 6:24 in the morning. Really, the argument stops at the point of it's not, we didn't do our job to get the Cellbrite version that shows that information did not exist at the time of the grand jury. So I'm not really sure how the Commonwealth is supposed to run something through a Cellbrite version that isn't in existence at the time the grand jury is conducted.
Come on,
It's a
man.
subsequent version in
I
which
know.
their expert, Mr. Green, finds these
FBI's in.
purported search without looking at the cache files, without looking at the DB list, without looking at the SQLite database, without looking at the wall file, all of which was done not only by Trooper Garino, an independent expert named Jessica Hyde, which counsel has all of those, as well as the senior technical analyst from Cellbite itself, a man named Mr. Whiffen. Counsel's had this report for months at this point. And essentially, Mr. Whiffen is essentially the person who creates the software that all of these experts are using. And his definitive opinion indicated in his report is that Ms. McCabe conducted those searches at 6:23 and 6:24 in the morning. So I would agree with counsel that it's really no longer up for debate. I think we just disagree as to the conclusions of that. But based
Dude,
on
the feds
totality of
investigated
the
it
evidence,
independently.
and what I would submit as the overwhelming evidence that was presented to this grand jury, all of these sort of individual parsing of stated malfeasance simply doesn't even come close to sustaining the burden under Odell. And for that reason, I would ask that the court deny the motion to dismiss.
Okay.
I mean, he's just saying that the
Do you want a few
FBI
minutes, Mr. Jackson, to
Right.
respond?
The FBI did their own
That's fun.
independent investigation of it.
gaslighting.
came-
First of all,
The definition of gaslighting.
it's always interesting to hear an argument that suggests there's nothing to see here. And that's exactly what Mr. Lally did yet again. He said,
Yep.
look the other way, look the other way. Oh, it's the defense that wants you to look the other way. We don't want you to look the other way, Your Honor. We
Look at
want
the
you to look directly at the evidence
Yep.
of the compromised relationships
The truth.
that Proctor had and hid. That's what we want the court to look at. He suggests, oh, well, there's just a couple of text messages. It's no big deal. It's a couple. The fact is, Your Honor, she really hit him. She really hit him with the car. Let's remember, she really hit him. And these text messages, they mean nothing. We're talking about the integrity of a sitting grand jury and the presentation before that grand jury. What Mr. Lally now has in his possession, but he didn't mention, now that he says, oh, well, she killed him. Let's just get on with it. She killed him. He's already tried and convicted her in his mind and tried to do it in this courtroom. Doesn't quite work that way. Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV
Here we go.
make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car.
Wow.
There it is.
The damage on the car was inconsistent with having made contact with John O'Keefe's body.
There
In
you
other
go.
words, the car didn't hit him, and he wasn't hit by the car.
The FBI.
Period. Full stop. That's their independent expert. Not
Wow.
ours. Not somebody on our payroll.
Wow.
Like Mr. Whiffen, or one of their experts, or Trooper Guarino, who's an arm of the agency. This is an independent federal government witness. or
Wow.
series of witnesses
Woo.
who said
Wow.
unequivocally, that car did not hit John O'Keefe. and
Wow.
John O'Keefe was not hit by that car. But he didn't mention
This
that.
is amazing.
Second, he
Wow.
argued that the texts were not, these aren't texts between Julie Albert and Michael Proctor. These are texts between his family members. And then he mentions these 2 texts that had no content. What are the chances that Michael Proctor sent Julie Albert texts with no content? Your Honor, it's not that they didn't have content, it's that it couldn't be recovered, which sometimes happens. But we do have evidence that they were, in fact, in communication with each other as early as 2020. And with regard to the 2:27 a.m. search, it's not a 3-card Monty. It's not a shell game or whatever other fanciful thing Mr. Lally wants to suggest that it is, as he tap dances his way around this. He says that our expert, Rick Green, didn't look at the SQLite database. Yeah, Mr. Lally, reread his report. Yes, he did.
Get him.
He didn't look at the wall file. Yeah, Mr. Lally, reread his report. Yes, he in fact did. And he's the one that found the 2:27 a.m. search. And with regard to the Regional Computer Forensics Lab, that's the definition he couldn't remember. What they actually said was, because Mr. Lally got this wrong too, what they actually said was, yes, there was a 6:23 and a 6:24 search. And there was a 2:27 a.m. search as well. All 3 of those searches existed in the phone,
Wow.
Jennifer McCabe's phone, and it's not up for debate. That wasn't presented to the grand jury. The information that we've been talking about today wasn't presented to the grand jury. We're talking about the integrity of a proceeding. We didn't
Right.
get to convict my client.
All the way
by
back to
standing
the
up here and
grand jury.
pounding the fist, pounding the table and saying, "Oh, she did it. She hit him. So let's just all get on with it. Deny this motion." We're talking about the integrity of what is the foundation of Massachusetts judicial system. And and that integrity was compromised, that integrity was impaired. And it demands that justice be done. And that justice is in the hands of this court. We ask this court to do what the evidence dictates, do what the law dictates, and that is dismiss this indictment. That is the only way justice will be found in this case. Thank you.
All right. Thank you very much. Mr. Yannetti, are you all set?
No. No.
So the same time, and let's see how you do with it.
Oh man, Yannetti's gonna get up there now too. This is
Oh, boy.
fucking fantastic.
Good, show them.
Yeah.
Show
Look
them.
at the
We
face.
believe our witnesses.
That's
They are
crazy.
telling the truth.
Show
Karen
them.
Reed is guilty. Any suggestion to the contrary is a desperate attempt to reassign guilt. Can you imagine a district attorney with a sworn duty to do justice and respect the presumption of innocence issuing such a statement in a pending case? Before August 25th of 2023, I could not. Yet that was the message of Norfolk County District Attorney Michael Morrissey to potential jurors in this case on that date. I've been practicing criminal law as both a prosecutor and a defense attorney for over 30 years now. Never have I seen such unethical conduct from a prosecutor.
Wow.
I know of at least one law professor who used Mr. Morrissey's statement in his class to teach his law students how a prosecutor should not act. Another member of the bar has already reported Mr. Morrissey's conduct to the BBO. And now we are here with a motion to disqualify Mr. Morrissey from further prosecuting this case because he has a personal interest in the outcome. Your Honor, this court should grant our motion to disqualify. And at the outset, I note that we've also moved for sanctions, dismissal of these indictments as a result of his misconduct. But we have so many additional grounds for dismissal as a result of the material provided to both sides by the federal authorities that we will be filing a further motion to dismiss for extraordinary governmental misconduct. My co-counsel has spoken to that previously. To the extent that the court entertains our motion for sanctions, specifically dismissal as a result of his
So
egregious.
can I just interrupt there and ask you, are these going to be the same motion essentially?
No. There's information and evidence that's been provided by the federal authorities which deals with the egregious conduct of both the district attorney and his investigators and the police. That will be the subject of a separate motion, Your Honor.
So I thought that was going to be your supplemental memo to this motion. It sounds like it's the same issue, Mr.
No,
Yannetti.
it's not. And what I'm saying to the court is I have limited time.
When I interrupt you, I stop the time.
Well, I
so-
appreciate that, but even with that, Your Honor, the focus of my argument is going to be on the disqualification as opposed to the dismissal. I've submitted papers on the dismissal. I will rest on those papers with regard to that issue. That's my only point.
All right, so when you file the other motion, I need you to include in your memo how that's different specifically from this.
Understood.
Not just the remedy, but how the basis of it
Understood.
is different.
Understood.
All right, so I'm going to start you again from scratch. Go right ahead.
I appreciate it. Well, Your Honor, this case admittedly has been an unusual one for a district attorney to deal with. The district attorney's office is not accustomed to a criminal defendant fighting back in the way we have prior to trial. What usually happens when the prosecution brings charges is they detail the allegations at an arraignment in court, and as a result, their narrative and theory of the case becomes widely reported, while the defendant and the defense team remain relatively quiet. After arraignment, moreover, the media typically lose interest and wait until a trial or potential resolution of the case before they start reporting on the case again. And in this way, the district attorney's office is quite accustomed to always controlling the narrative in pending cases, at least until the defense makes an opening statement at trial. And as long as the prosecution gets to control the narrative in the press, they have no problem with what's being reported. But of course, this case has been different. Their control of the narrative did not last very long here. In our view, it became clear very early on in this case that their narrative was wrong. Their theory of the case was wrong. Their allegations did not fit with the evidence that we fought so hard and for so long to get access to over 2 long years. So along the way, we spoke out about our findings of exculpatory evidence, mostly within this courtroom, but occasionally outside. The DA was not used to that and apparently didn't like it because they initially sought the extraordinary remedy from this court of trying to gag the defense from exercising our First Amendment rights to discuss a client who at all times is presumed to be innocent. And as you know, they filed that motion on June 9th of 2023, and it didn't work. The court denied the motion, specifically ruling that any statements attributed to counsel could generally be characterized as responses to the accusations against Ms. Reed and are therefore permitted under the rules. When you made that ruling, though, Your Honor, you admonished both sides that commenting on the credibility of witnesses would have a prejudicial effect on the proceeding. And at that point, we largely stopped making extrajudicial statements. By contrast, Norfolk County District Attorney Michael Morrissey, only 25 days after that court's ruling, instead decided to blatantly ignore this court's admonishment. DA Morrissey went off the rails, gave an unprecedented video statement to the media where he specifically vouched for the credibility of Commonwealth witnesses in violation of the rules of professional responsibility, in violation of this court's order. A member of the public issued a public records request, and we got this to show all of the media outlets that DA Morrissey made sure received his statement. Before any trial has occurred, he called the defense theory in this case, quote, a false narrative. Before any trial has occurred, he announced his opinion that nobody within the home at 34 Fairview participated in any murder or any cover-up. Before any trial, he vouched for the credibility of Commonwealth witnesses Jennifer McCabe, Matthew McCabe, and Brian Albert. He announced that those witnesses were forthcoming. In other words, truthful. Before any trial has occurred, DA Morrissey announced that the defense theory is, quote, a desperate attempt to reassign guilt, end quote. Given those broad statements of Mr. Morrissey's opinion that Karen Reed is guilty, can you believe that the DA in their opposition to this motion had the audacity to claim that DA Morrissey's words were narrowly tailored to the harassment of witnesses? It goes without saying, but your words are not narrowly tailored if you're a prosecutor vouching for the credibility of witnesses, particularly after a judge told you not to do that. Your words are not narrowly tailored if you're announcing to the public that you've already assigned guilt to a criminal defendant before trial. A desperate attempt to reassign guilt. DA Morrissey announced to every potential juror in Norfolk County, not that someone charged with a crime is innocent until proven guilty. The words innocent until proven guilty never came out of his mouth. Instead, he announced his office had already assigned guilt to Karen Reed. So in his view, when she fought back by reasserting her right to be presumed innocent, he deemed that a desperate attempt to reassign guilt. Never, in over 30 years of practice, have I ever witnessed an elected DA so blatantly violate the rules of professional responsibility. Never have I witnessed an elected DA trample on the constitutional rights of a criminal defendant who enjoys the presumption of innocence. And I do have some perspective in this area. I had the privilege of spending the first 10 years of my career as an assistant district attorney in Middlesex County. I had the privilege of working with and for some of the finest DAs this Commonwealth has ever seen, from Scott Harshbarger to my mentor, Tom Riley, to Martha Coakley, Jerry Leone, Marion Ryan. In addition, I worked with some of the finest Massachusetts state troopers acting as homicide investigators, men and women I respect for their integrity and prowess as ethical investigators. In a million years, I could not imagine any of my former colleagues and bosses making such a statement. They were professionals with ethics and a humble respect for the awesome power they possessed as public prosecutors. So for those reasons, in some ways, it pains me to have to file a motion like this. But DA Morrissey, through his poor and unethical decision-making, to release a video statement designed to prejudice potential jurors against my client, has forced my hand. So the question then becomes, why did he do this? Why did he take such a personal interest in this case, such that he would take the unprecedented, and that's his word, unprecedented, step of vouching for Commonwealth witnesses? Why would he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Read is guilty? Why would he trample over the presumption of innocence and announce that we're trying to reassign the guilt that he's already assigned to her? Well, on December 4th of 2023, we began to learn why. That was when the DA released to us correspondence he had had with the U.S. Attorney's Office, which dated back to May of 2023. That correspondence revealed that federal authorities were investigating this case. And it's worth noting, they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the acting U.S. attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the district attorney's office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury. We now know that was a lie. Wow. We know it's a lie because 7 months earlier, DA Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson. A group conference call before she testified before the federal grand jury in July of 2023. We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury." Yet 7 months later, the DA's office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. In a prior hearing in this case, I argued to this court that the letters back and forth confirmed that DA Morrissey believed that he personally and his office in general was being targeted by the U.S. Attorney's Office. I chose my words carefully. I never said he received a target letter. The existence of a target letter is irrelevant. The inquiry is, what does the DA know and believe? And he revealed in those letters what he knew and believed. He revealed that he believed that U.S. Attorney Rachel Rollins had a personal animus against him. He wrote, quote, "She's made no secret of her personal animosity towards me." He also wrote that the head of the public corruption unit of the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted. Now, why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. It is important because, in the words of U.S. Supreme Court Justice Robert H. Jackson, quote, "We must have assurance that those who wield this power will be guided solely by public responsibility."
So I just want to tell you, you've gone over your time. I see you're reading, so you have some idea on how much longer you have. How much longer do you have with that?
Sorry for boring you.
About 3 minutes, Judge.
Okay, yeah, go ahead.
Thank you.
Letting him talk.
Indeed, Your Honor, Justice
Right
Jackson
on.
practically
Right on.
Right.
spoke to DA Morrissey from the grave. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have citizens' friends interviewed. Prosecutor can order arrests, present cases to a grand jury in a secret session, and on the basis of his one-sided presentation of facts can cause the citizen to be indicted and held for trial. Well, while the prosecutor at his best is one of the most beneficial forces in our society, when he acts with malice or other base motives, he's one of the worst. In his own words, DA Morrissey revealed he has an interest in this case that goes beyond the interests of justice. He revealed that he knew that his office was being unfairly targeted and investigated. And it doesn't matter if his belief or knowledge was right or wrong. It's only important that he believes it. And this means he has a personal interest in getting Karen Read convicted. If he can use whatever means he has at his disposal to convict her, and he succeeds, that would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation. And it's important to note, Your Honor, both sides have been made aware multiple times that as we have this hearing today, that federal investigation is still open. They've called most of the Commonwealth's witnesses to testify, but they're not done.
Wow.
DA Morrissey has an interest in this case not to do justice, but to win. That's why he hid his knowledge of the federal investigation for 7 months. That's why he slow-walked discovery. That's why he gave a lengthy video statement saying Karen Read is guilty. That's why he talked about our theory being a desperate attempt to reassign guilt. And perhaps that's why, in contravention of Judge Krupp's preservation order, DA Morrissey's office gave the go-ahead to Brian Albert and Brian Higgins to destroy or dispose of their phones. We only learned that because the federal authorities revealed that in their investigation.
What?
And I'm just about ready to end.
What?
The DA also, as my colleague has indicated, I'm sorry, the FBI has confirmed that Jennifer McCabe Googled, how long to die in the cold at 2:27 in the morning. But what has not yet been mentioned is that 5 minutes before that, Brian Higgins and Brian Albert were calling each other at 2:22 in the morning on January 29th after previously testifying they were both asleep at that time.
Oh,
Wow.
Suspicious activity in the early morning hours of January involving the witnesses that Morrissey improperly announced to the public were telling the truth. We're getting to the bottom of it, and the truth will come out. But as we continue to defend her, Your Honor, like any criminal defendant, my client deserves a neutral, impartial prosecutor interested solely in justice with no vested outcome in this case. And it's crystal clear we do not have that in Michael Morrissey. That is why he should be disqualified from this case. And that is why I urge you to do just that in the interest of impartial justice.
All right. Thank you very much. Who's arguing this? You, Mr. Lally? All right, so let's start with 10 if you need more.
This guy just wants to die right now.
Karen is just like, Karen Read is glowing.
Thank you.
Right
Your Honor. And again, I don't think I'm going to need much more than that.
Can't believe you're not giving up.
Yeah.
Again, I know the court
You're right,
has
Aiden.
reviewed all the materials, and I know
100%
the court
right.
is well aware of their standards.
This
and
is
its
the
standard,
craziest thing
which I
ever.
would submit just simply hasn't been met here. To characterize counsel's actions in this particular proceeding with specific reference to the media and saying it's different, I think is minimization to the highest degree. Essentially, what the defendant is positing, or what counsel is positing in this motion, is that due to a recorded statement by the district attorney over 6 months ago, that impinges on her right to a fair trial, or it impinges, shows some sort of deleterious motive on behalf of the district attorney in the handling of this case. The statement, as the district attorney indicated in it, was in response to an extraordinary degree of relentless and really relentless harassment and intimidation of nearly every witness associated
Here we
with this
go.
case, which included a July 22nd rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers.
They are.
Come on, man.
That is largely what this was in response to, and is in complete conformity with Massachusetts Rules of Professional Conduct 3.6b6 that permits an attorney to make a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists a likelihood of substantial harm to an individual or to the public interest. It's also in conformity with Rule of Professional Conduct 3.6c, which allows for such statements to rebut the prejudicial effects of the defendant's and her counsel's misconduct. Now, again, I know the court has read through the Commonwealth's opposition, but just to highlight a few of those particular incidents. So yes, the July 31st, I believe, was the ruling in regard to the, for lack of a better term, a gag order. And I think it's been somewhat inappropriately or just patently falsely represented to this court in public what that ruling said. It indicated that the statements of counsel arguably crossed the line of permissibility under Rule 3.6, and that meaning defense counsel. That the inflammatory statements about the Commonwealth and witnesses, particularly by Attorney Jackson, appear to have fueled much of the publicity in this case. And that's a quote from the court's ruling. And that the defense counsel did not have carte blanche to speak with the media, and going forward, defense counsel should ensure that their statements are limited in conformity with the rules. And it denied the Commonwealth's request for that gag order at this time, denying it without prejudice. And then Mr. Yannetti wants to get up here and say that they largely stopped making extrajudicial statements after the court's ruling. And so I guess largely stopping would then include August 22nd, the day before the district attorney's statement, a ABC News broadcast in which Mr. Yannetti and Mr. Jackson were featured for a 9-minute, 37-second segment, in which Attorney Jackson indicated that pieces of taillight were planted after the fact, that the victim walked into the house. I think he was confronted, was likely brought down to the basement. I think the confrontation got physical, and he was beaten to a point of unconsciousness, that he had defensive wounds, bruises on the back of his hands, largely of which is all not only not true, but directly contradictory to the vast amount of evidence that has been turned over in this case. Mr. Jackson then went on and continued that this was a cover-up, and indicating that John was murdered inside that house, his body was placed outside. This also continued into September. September 17th, the defendant, traveling with Attorney Jackson, Attorney Little, and a woman believed to be a television news producer, to the victim's home, to Mr. O'Keefe's home, in direct violation of her conditions of release, where she has to stay away from,
Then why wasn't she arrested?
as well as
So
other
what?
places of interest and sort of
Arrested.
tour around the town of Canton. When balancing the amount of public and prejudicial statements made by the defendant and her counsel, the Commonwealth would suggest that then characterizing the district attorney's statement from over 6 months ago, threatening her right to a fair trial, is simply a position that's just untenable. Now, in context, as far as those particular statements,
Yes.
those particular actions go, as the court is well aware, there is a significant history between this defendant, Mr. Yannetti, Mr. Jackson, and the social media blogger, Mr. Kearney, who's now been indicted for intimidation of witnesses in this
God.
case. And with reference
Holla!
to that, there is a significant, despite public indications to the contrary, that indications from Mr. Kearney's phone, which was seized, is that there is a
Fuck you.
precipitous amount of phone communications, indications of communications between Mr. Kearney and Ms. Reed on a signal
Get the
messaging
fuck
app,
out of
an encrypted app, as well as, I believe, about 189 phone calls over a span of a few months. And that's just what's indicated or contained in the phone. There is also, going back to the spring of 23, direct communications between Mr. Kearney and Mr. Yannetti, and Mr. Kearney and Mr. Jackson. They went out to lunch with Mr. Kearney following a court date in May of
He
2020.
wasn't there.
Who
This
gives
is
a
a person
fuck?
who counsel in the memo seems to want to distance themselves from, based, I'm presuming, on subsequent indictments. But the truth is in the phone. The phone doesn't lie as far as those communications are concerned, as far as those communications between counsel and between the defendant in this particular case. So to say that this is a different case, again, I would suggest is a large minimization of what actually has transpired here.
Smoke and
Lastly, what I'll
mirrors.
say in reference to the federal grand jury, what is also clear from the federal grand jury is that this was an investigation which was initiated by the defendant and Mr. Yannetti. So to claim that he was in the dark or didn't know about this federal investigation, every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti. Nothing was asked for from the Commonwealth. Nothing was asked for from the district attorney's office, the state police. So again, what I was intimating before in reference to the motion to dismiss, I have no idea what they have seen or what they haven't seen, how much of the file, how much of the discovery or anything else. It's all sort of been provided and colored by Mr. Yannetti. And this goes back to November of 2022. So to then claim that you were sandbagged or didn't know about an investigation that you initiated over a year before until late in December of 2023 is, I think, disingenuous.
Disingenuous.
Disingenuous
Oh.
would be about the nicest term that I can come up with for that. Thank you.
Right.
That's what you
Maybe
got,
short,
dude.
Rebuttal, I guess.
Oh
Or
boy,
short
bad. That's all they got.
comment.
Wow.
I would
Smoke
just
and
add, Your
mirrors.
Honor, that the focus of Mr. Lally's argument was on everything except for Mr. Morrissey's conduct.
Right.
Just like it doesn't matter if Mr. Morrissey and his office are actually targets of an investigation, it's only what he knew and believed. Similarly, with regard to his conduct in keeping secret the existence of a federal investigation, it doesn't matter whether we knew about it or not. It's the fact that Morrissey knew, kept it secret for 7 months, and didn't reveal it to the defense until the media got access to those letters. And with that, I would rest.
Okay. Thank you. So I do have a question. Did you file the Rule 17 motions already, or do you expect to file them later today?
We will be filing them by the close of business today.
Okay, and they're pretty much outlined in your previous motion, what you needed to file, or are there additional ones in your
I
motion?
believe
with the
they're
container?
outlined. Yeah, they're outlined, Judge.
Okay, I asked because Mr. Roach told me that on the March 20th date, the council wants it to be via Zoom. I'd prefer it not be, because with Rule 17, as you know, the record holders come into court and object. So I don't want you all to be on the screen. And Mr. Yannetti, certainly your local counsel. Mr. Jackson, if you want to be on the screen, you can. But I need somebody here,
I understood, Your Honor. That's fine.
okay?
That's fine.
It makes sense to me.
If I may just,
Yes.
can I appear in person and have my client join me?
No, she has to be here.
Okay, thank you, Judge.
All right. Was there something else? Yes.
I would ask, may we approach just as the scheduling issues?
Okay.
So when they're setting up a Zoom here, like this, there's going to be something before the scheduled trial
Yeah, on the Rule 17 motion.
for whose phone? What's the Rule 17 motion for?
I'm confused on that. too.
Right. Yeah, I don't know.
Oh,
either.
we're done with Rule 17s.
Yeah. This should just be dropped today. This is embarrassing.
I mean, I can't fucking believe that
Yeah.
loud.
Like-
None of that mattered. Like everything you heard, the bombshells, FBI reveals
The feds.
he was never hit
Dude.
by a car, and they're just like, let's talk about Turtle Boy's lunch.
Right. Like
what
the fact that the fact that he even brought you up after all of the bombshells that were dropped by Yannetti and Jackson. Like that's what you got to come up here and say is Karen Reed and Turtle Boy talked to each other and had lunch. Are you fucking shitting me right now?
How about the destroyed cell phones?
The Higgins was ordered to destroy his phone.
Roy's
Is that
phone. And they were texting 5 minutes just before the Google search. How long to die in cold?
Look at these morons.
Dude, it was federally investigated and concluded federally that the 227 call happened. I don't
Confirmed.
know what else it's
It
going to
was
take for
confirmed
people to
federally
understand.
that John O'Keefe was not hit by a car.
Yes.
Dude, Turtle Boy, there should be a line of people ready to kiss your ass for the fact that you went to jail over this shit. This
It's a lot
is
to take in right now.
fucking,
If I
you
see-
must be infuriated about that.
And the expert that confirmed John wasn't hit by Karen and no way was hit by Karen had 3 PhDs and was an independent federal investigator. Had
Dude.
literally nothing to do with this case. Just asked to come in and say, what do you think?
I was
I mean-
charged on a fucking lie. Everything I said about the relationship between the Proctors and the Alberts was confirmed.
All true.
today.
All
The
true.
questions I asked Jennifer McCabe were about the Google search, which is confirmed to be true.
True.
Everything I said
He
was
wasn't even hit by a car.
Yeah, wasn't hit by a car.
He was not hit by a car. This was a federal, independent federal
they
investigation and
arrested
conclusion
me
of
for
it.
that. They charged me for that. They put bail on me for that. And then they revoked that bail, which was based on a lie. The bail itself was based on a lie, based off of another lie from some side piece who is not even in the courtroom right now because I announced I wasn't going to be there. She only shows up when I announce I'm going to be there. I mean, if I don't seem happy right now, it's just because it's a lot to take in that I did all this
Yeah.
fucking lie.
I mean, I appreciate you for it, man. I mean, you know, you did that. You could have pled
They
out
wanna send me
and got
back
out
in
of there.
days for a fucking lie. I mean,
You
they
could have
want to
pled out
revoke
and
my
got out of
bail
there.
based on this fucking lie again.
Because that's, I mean, you did that for the sake of people's First Amendment rights. That's it's a hell of a thing. It's nothing to shake a stick at, and it's nothing to fucking minimize. And so we're all grateful for that. But but I if I were you, I would be fucking pissed. I'm pissed for you. Everybody in the chat is, because you did 2 months out of your life over just trying to get justice, trying to get to the truth.
I just don't know why.
The 222 thing. Let's review that. The Bryans are awake and calling each other at 222. So Brian Higgins and Hal Albert were calling each other at 222. And they previously testified that they were sleeping at that time.
Yep.
Yeah.
Higgins,
I'm sorry. I said text messages. I'm sorry. It was phone calls.
Didn't Higgins like sign into work at 1:30? That was his story. That he signed into work.
Right.
Yep.
And so I didn't know Albert testified that he was sleeping by then. 222. He testified he was sleeping at 222, and he's calling him. Wow.
I don't know how the Commonwealth can sit here and Lally can sit here today and
How did they get that?
with the charade.
How did the feds find that out?
I mean, I'm sure it's in that
It was
document.
extracted. I think it was. They said it was extracted off
That
their
means, they have
phone.
that means they have Brian Albert's phone records, something Karen Reed's defense team.
Dude,
should
how
not
much exculpatory evidence do you need? Like, what is this going to take? This is the most insane thing I've ever seen in a courtroom, besides Daryl Brooks or
It was
Darrell
phone
Brooks.
extractions.
Like,
TV.
this is
Let me
madness.
let me just read some turtle chats real quick. And now we got a break here. $100 from First says, "You guys rock. Thank you for doing this.
Thank you.
Appreciate that."
Yeah.
Jersey sends $5 and says, "My 3 favorite men in one stream." Lots of love from
Thank
Green Sea, South Carolina. Free Karen Reed. Love you, Daddy. Love you too, Jersey.
Thanks.
Colpry Son sends $25. Says, "I appreciate your hard work and dedication. I also think your personal style of reporting doesn't need changing, as some have suggested. I watch you for you, not how people want you to be. Keep up the good fight. Quincy loves Daddy." Well, I appreciate that because I get a lot of crap for that. So thank you very much, Colpry Son. Jennifer sends $10. Says, "This trio is a dream come true. Thank you guys for all that you've done and continue to do. Our eyes would not be open without you all." Thank you very much.
Thank you.
Caitlin sends $5. "Glad to see the three best of the best today. This is going to be a great show. Free Karen Reed."
Wow.
Thank you.
This is like the biggest show I ever had was my first one back from jail. And now I think we got like 65. We got
6,200 in the chat right now.
That's wild. Hopefully people got screenshots of that.
Yeah.
Fucking awesome.
This is- yeah.
I mean, we could
This
still
is, well, I mean, this is the craziest court hearing that I've
Yeah.
ever like covered live. Like, this is easily like up there with one of my favorite live streams I've ever done.
yeah. Yeah.
Because this is insane. Like, just bomb dropping after bomb dropping. I just don't see what, like, they wouldn't say that these things were confirmed by a federal investigation, an independent federal investigation, unless they could prove it.
Right.
You know, like this, and the prosecution has nothing
I
to
wonder
counter
if
it.
I wonder if in sidebar right now they're literally sitting there like, "Come on, Lally, you really want to keep going forward with this right now?" Like,
Wait till you
Why
see,
is it? I'm sorry. Go ahead.
wait till you see the grand jury testimony they got.
oh yeah,
Like, let's just put it like this thing today that Proctor texted Julie Albert looking for a babysitter 2 weeks
Yeah.
before he died. Wait till you see what Tully testified.
Here we go.
Wait till you see the lies that these fucking
All
people.
right, you had a question, Mr. Jackson?
Okay.
Yeah, Your Honor,
fucking
just
wild,
the
man.
logistics of the trial, meaning days in trial, half days, 5 days a week, 4 days a week.
I'm gonna go
I
through it.
wanted to get some sort of sense so we can begin planning.
Okay,
what
so
the
we're
court-
going to go full days, Monday, Wednesday, Friday, half days, Wednesday, Thursday,
Are the half days afternoon or half days morning?
mornings.
Just for the trial.
You're going to trial with this. This is it's fucking unbelievable.
She has
Anything else?
not the motion to dismiss yet.
Yeah. She has to rule on that.
Oh,
first.
that's true too. I'm sorry.
She's saying if it goes.
But will she do that today? Will she rule on the?
She ain't
Because
gonna-
that's what
No,
this is,
they'll drag
right?
this out.
I think she'll take it under advisement.
Yeah.
Right.
There's Jim. Look at Lally. He just wants to go and crawl under a fucking rock.
No, Your Honor.
Can't
Mr.
take that guy
McDermott?
serious.
Judge, I just wanted to put on the record that I think I provided to everyone copies of that letter from Google. I just wanted to make sure, just put that on the record that I gave you copies of that. Thank you.
We received copies.
All right, great. All right, thank you very much.
Thank you, Your Honor. Thank you.
That it?
Well, Karen should keep her head up high today. A lot of good things in her favor get on the record.
So what now?
I want to see this parade of assholes out. Wow.
I mean, dude, the feds basically vindicated you, dude.
Yeah.
I know. It's a lot to
Like-
take in.
How can this go to trial?
Yeah.
It's a lot to take in, man. It's something, man.
This is insane. This is the wildest shit that
Yeah.
I've ever experienced on YouTube, ever in my life.
So they're letting all the McAlberts out first. Okay. Well, no Jennifer McCabe today.
Yeah.
Very interesting.
Notice that.
Very interesting.
That is interesting.
And obviously, too, no Lindsay Gattani either. On the day that I announced, I'm not going to.
Right.
She only has
You're right.
and she knows I'm going to be there.
What's up, Olivia? I saw Sleuthy in there earlier too.
Oh
What's
yeah, I
up?
saw Salute too. Yeah.
No Chris Albert today. I mean,
And
they must have
Benjamin-
known this Google shit was going to come out. They could not face the O'Keefes.
Shout out to Benjamin John too.
Hey, I
Lauren.
wonder how
TV
Coffindaffer's feeling today.
Yeah. I'm going.
I mean,
I'm gonna switch,
oh my
I'm
god.
gonna switch to Tom
Go
CPU.
to Tom. Yeah.
Yeah.
That was insane.
Here we go. That was crazy. Found out a lot of stuff today.
Yes, we did.
A lot of new stuff. A lot of new stuff, TB, that you can dig into, buddy.
What the hell was that? He has no sound. Is that right? People are saying. Wow, that was
That's what it seems like.
wild.
Yeah, you're not muted.
Oh no.
Is he gonna get? Are we gonna see faces or just stares, Tom? What are we doing? What's
Tom,
going on?
Here we go.
We're counting on you, Tom CPU.
Tom, you need sound, buddy. Let him know. Someone let Tom know down there. He's muted.
What's that?
There we go.
there we go. All right.
All right. Go, Tommy, go.
What a hearing.
Incredible.
Got it.
Incredible hearing. Karen should have her head up high today and smiling.
Yeah, how are the trolls gonna spin this one? I mean, because
Yeah,
they
right.
will. There's no way they'll ever accept it.
The Fed-
Ever.
I mean,
Alright.
Ever.
Camera guys.
oh, I
let's get a
can't
fall.
wait. I can't wait. I can't wait till Plevin's next live. Oh my god, I can't wait.
I mean, it's going to be. Well, the FBI investigators are wrong too. They're being
Right.
paid too.
They're,
Like,
they're probably getting paid too, right?
Yeah, they're getting paid, right?
we have lunch. Natalie said, you know.
That's what he'll say. He'll say there's corruption, like that Levy's corrupt, and
it's one thing if
That's what
like
else.
the Plevins of the world do it. The problem is that
Right.
fucking Adam Lowley's of the world do
Right.
right.
it. Like he just ignored everything. Like none of that fucking happened.
How are you?
I did find it interesting that on the Fed,
There were two
This is
gave
fascinating.
extra time to both Jackson and Yannetti. And she never is
Yeah.
gracious enough to do. It's like she
My
wants.
blind side.
I think she
Three
recognizes the
card
importance of.
Three card monsters.
I know. Wasn't that good? Hello.
What's Jennifer Coffindale saying? Ethan, I
Yeah.
can see her.
Oh my God, I can't wait. Jesus, there's
It's confirmed by the
Like-
Fed. Her own people confirmed it. Her own people confirmed it.
Oh, she's just
I
playing
mean,
for me.
right.
Yeah,
Yeah,
I'm gonna
Coffin
read her
Upper's
tweet.
own.
This is
Oh,
her
she-
tweet right now.
I know.
For the individual
Why?
making money hand over fist by perpetuating narrative with no facts to support, I certainly will not be joining you in any venue. I will be discussing the case with others with integrity who raise the reasonable arguments and points in multiple venues. I recently received very serious threats towards me and my children
Yep.
from this
Oh, God.
individual. She's saying I threatened her. This is clear
Wow.
evidence of the unhinged nature of this person. I will be
Yeah.
filing a
5
police
million. Remember that?
stay away from my
Yeah.
family. Also, quit contacting me via emails. For those who follow him, I hope you take as deep a dive
There
into
we
him as you
go.
have. I'm going to sue the fuck out of this cunt. I hope she knows that. You can't just make up fucking lies. You cunt. I never fucking emailed
Okay,
you.
this brown finger.
Fucking piece of shit, Jennifer Copendaper. Unfucking believable.
Oh my God.
Unfucking believable. That never happened. I have never emailed you, you stupid cunt.
Wow. I mean, you have to prove that. You have to prove it.
She said she filed a police report.
Always. See, I'm right there. Yeah.
I am so sick of this.
No kidding, huh?
I mean, it's typical too, right? When you have no more argument, what people like her always do, when you have no more argument and you look stupid, you go the play victim route.
Mhm.
You play the victim,
Yep.
you know, and
Right.
that's what she's doing now. She's, oh, now I'm threatened by, and just, I mean, this farce that we just watched the prosecution
Right.
display, she's gonna hang on to. And what else would we expect Jennifer Coffindoffer to do at this point?
So
Yeah,
she's
but-
ignoring her own people, the feds, that literally confirmed everything
Right.
that happened.
Well, somebody says to her, Haley Walbrecht, who's a great follow on Twitter, says, you vouched for facts and people. The federal investigation is now found to be evidence of a cover-up. Maybe doubling down here isn't the correct move. She responds, inaccurate. Your understanding of a public corruption investigation may be what's leading you astray. It's like they just made, like, facts don't matter. Like, they literally just fucking said you didn't get by car. You didn't get by car. Fucking FBI said.
Oh my God.
Oh,
I
her own
love that
people.
lady, bro.
Somebody says to her, the FBI confirms the how long dying cold thing happened in 27. Jennifer Copendaper responds, please show the report. Thank you. Oh, so I guess he's just making it up. I guess they just fucking
It's in the
made that
grand jury testimony.
up. I guess they just fucking made that up. They entered in fake
Right.
FBI.
It's on the record.
Wow. Well,
Dude, like, I mean, there could be indictments, man. There could still be. Dude, they just kind of gave cliff notes on that federal document, on that 3,100 page document. So who knows? Who fucking knows how much shit
Yeah.
that they have to where they can hand
Yeah.
out indictments
Chrissy on the way
and
in.
actually get John O'Keefe justice once and for
Trying to
all.
be.
Yeah, and keep in mind, Jackson didn't get all his points on the record today. It's in the memo, but he didn't get to read them all in court. So there's probably more stuff that we didn't hear, but he wanted to get those, the very powerful points out there to the public so they know. There's
Yeah.
more. There's more in that memo.
Oh,
Believe
we
me.
sure.
knew the Google search
Yeah.
happened, of course, but now it's just confirmed by a federal investigation. Look into that. God knows what else they fucking found. Those text messages between, I'm gonna have to re-listen to this whole
The
thing.
phone calls.
Yeah. I'm gonna have to like do
Five
my
minutes
own.
before the phone calls, Higgins and Proctor.
Yes. Let me read a couple more turtle chats because I got a big one here.
Awesome.
I wanna be
Good. How are you, my dear? Good.
Jenny B sends
Good seeing you again.
$534. Holy fuck.
Ah,
Jenny B, I love you. And she says, Jesus loves you, Aiden.
That's great.
Thank you.
right on.
Yeah.
I love you
Good
and
stuff.
Jesus. Thank you, Jenny B. I really appreciate that.
Wow, good stuff.
Jamie sends 25, says, Aiden, you will be vindicated. We all know who you are. Don't let them get you down. Today, is a good day. I mean, I feel vindicated, but I also feel robbed. And I'll talk more about that on my show tonight.
Yeah, man.
May sends $10, says, Carr didn't hit John. John didn't hit Carr.
Yep.
Game over, fucktards.
I
Absolutely.
wonder what Berkey's doing. That's
Amy
a
sends
friggin-
$25, says, please don't.
What's
Okay,
Berkey doing?
I'll read
today?
out loud.
Anyone know?
Thank you. Okay, thank you, Amy. Lori sends $20, says, breathe on deep. Way to see through this and sacrifice severely. You've been exalted and you wear it well. Thank you very much, Lori. Elizabeth sends $100, says, Kevin can go fuck himself. Absolutely. The Spectre report sends $5, says, grand juries never get all the information and definitely don't get the exculpatory evidence. Attorneys almost never call the other a liar on the record in court. And if Yannetti is saying it so openly and forcefully, this should be looked at. Absolutely, the Spectre report. Danielle sends $15, says, you are clearly overwhelmed with emotion and rightfully so. It is a lot to take in. Nothing better than being vindicated. You brought this to fruition. Thank you for everything you've done. Thank you, Danielle. I appreciate that. DW sends $50, says, vindicated, and it feels so good. Thanks, Unc, LTL, and Will for doing this stream. Huge
Thank
day.
you.
Thank you.
Thank you for supporting
Thank you.
Turtle Boy, man.
Yeah.
This
And,
is, you know,
And how I got Howie Carr calling me right now. Hold on. I got
nice.
Yeah, take that.
Really? Are you serious?
Hey, what's up, Howie?
Nice.
Nice.
Put her on speaker.
Yeah, were you watching the court proceedings? Oh, yeah, they announced that the 227 search, the FBI found that happened. They also found out that John was never hit by a car, the FBI investigation revealed. They investigated that, found that Proctor was texting Julie Albert, asking her to babysit his kids 2 weeks before John died. And they testified in the grand jury that Michael Proctor never knew
Live the
anything.
tape.
And Higgins and Proctor text messages 5 minutes before
Yeah,
227.
Yeah, it all came out. I mean, they're not going to stake their reputations on something that's completely untrue. They're not just making this up. And then the prosecution responds with basically, Turtle Boy's a bad guy. Their entire response was, Turtle Boy's a witness intimidator. He's a bad guy. He's been charged. They went out to lunch one time.
Wow.
That's correct. That's what their forensic investigation said, that he was not hit by a car.
I love it. Fucking love it.
So everyone that's complaining about the stairs.
They
is why
filed
I'm
the
at
motion to
stairs.
dismiss today. That's what today was.
Look at Tom.
Yeah.
Attaboy, Tom.
That's-
Attaboy, Tom.
Yeah, I'll come on tonight. What time are you thinking?
Look at that. That's a beautiful sight right there.
Yeah,
Yeah, I got
Okay.
them over there too.
this is absolutely huge. So I got to jump. I'm on my
Spot right
stream right
here.
now, but
So
okay. Yeah, 30 minutes is good. 6 o'clock would be better, but yeah. Yeah, 6 is better. Okay. All right, sounds good. All right. Going on Howie Carr at 6:08 to talk about this.
Awesome.
Nice. Yes. I love it.
That was Howie. He was blown out his mind. He's just like,
Yeah.
I can't believe this. He's like, how is this not immediate dismissal?
Right.
How is this not immediate dismissal?
This is right.
Wow.
Nice crowd out there.
Wow.
Like
Thanks for
it's
supporting
official,
everybody.
Like there is an official report by the U.S. Attorney. There's an official report.
Yeah.
That like through federal investigations, like the FBI, and you know what? Right there, that should be dismissed. This
Yep.
should absolutely be dismissed.
Let me read a couple more turtle chats.
Yeah.
Rooster sends $20. He says,
Yeah.
do not read the class, so I won't. Maybe I'll read that later. Got a couple cash apps here. Also, I got to bank through. Give me one moment. First up, we got, let's see. Let's start from the bottom here. Okay. Orcaleb sends $1.99. Says, for Trio Nipslip. Okay, thank you. Patricia sends $150.
All right.
He's finally from Krusty for your family. Absolutely. The witch is dead. Carrie Becky sends $25 and says, Auntie Bev is a Cuntosaurus. No disagreement there. Pina Rosa sends $5. Says, Alan Jackson, president. Absolutely. She also sends $5 and says, justice is here. Bang, bang. Thank you. Sarah sends $15. Says, thank you for all you've done, Eden. I appreciate that, Sarah. Thank you. Today feels a day of vindication. Nicole sends $20 and says, thanks for streaming Free Karen Reed and Turtle Boy. Aubrey sends $20 and says, "We love you, Turtle Boy. I love you too, Aubrey. Thank you." Bob sends $20 and says, "I got chills hearing all that evidence. Tell me about it. Love you."
Yeah,
Please.
dude.
Whew. If anybody else wants to donate, the link is at the top for Turtle Chat, or you can cash at me at $ Uncle Turtle Boy. Okay. Wow. The phones in the pool. I mean, this is fucking madness, dude. Madness.
Dude, I'm fucking jacked right now. Like seriously, my heart was pounding watching, like listening to these to Jackson, man. Like that dude is a fucking rock star.
The one that really sticks out to me again, and I go back to confirming if Karen's SUV hit John. They had a independent federal investigator that had 3 PhDs that confirmed it did not happen. Someone that didn't have anything to do with this case went in and independently looked at it and said, it didn't happen. Didn't happen.
I mean,
Yeah.
Now we know where those injuries came from. They came from inside 34 Fairview.
inside.
They had to.
Yeah. I mean,
They had
by default. And this is
Right.
why the Fed told David Yannetti that they can't in good conscience allow this to go to trial because they knew all this.
Yep.
They knew all this.
I still have hope that John O'Keefe will get justice. I mean, that was so rewarding to hear that vindication from a federal investigation, an independent federal investigation came to these conclusions. And I see this investigation going the only place it can go. If it's not Karen Reed's SUV, it's the people inside 34 Fairview that night.
Yeah, by default.
And-
by default.
Right.
By default. They didn't even talk about the Apple Health data showing them ascending and descending stairs, nothing like that. They didn't have to.
And then Lally to go on and say, well, no one came out that night. Even the neighbors didn't come out. To me, that's weird. That's a red flag. That's weird. You have all
the
that
phone
activity
call.
that's in and around 34 Fairview, but no one comes out. That's
Right.
weird.
He said that the neighbors didn't come out.
Yeah.
So like it's not unusual that he didn't come out because the neighbors didn't either. Bitch, there wasn't
That
a body
means
on their
everyone
front
that
lawn.
testified
Yeah.
lied.
And what about Lank?
He was
What
at the
about
house.
what about the Lank bombshell? Like all the way back to what? 2002?
Well,
They said?
I reported that in like part 10 or
Oh.
something of the Turtle Boy series, like the Lapalato brothers fight. I talked to the
Okay.
prosecutor in that case. It was called
Oh,
Bamboozle.
okay.
Yeah, like Lank was drinking with
No,
Chris Albert. Chris Albert got in
no
a
one's
fight,
talking to Grant.
and then Lank clocked into work drunk and wrongfully arrested the 2 guys that that Chris Albert willingly got in a fight with.
Wow.
My lucky turtle from Hawaii.
And Lank was one of
Hawaii.
the officers in the Sandra Birchmore case.
Oh, there's Brown Finger.
What?
Brown Finger.
I is Grant like, the first one.
Are you asking me to punch you in the face? Is that what you said? I can't hear you. What?
Oh God! Don't
What do you
not do
say?
this. Come on, Tom.
That's what I thought.
He's saying
Fuck him.
27 happened.
Yeah.
Don't worry about
They
him.
have nothing now.
They
They get a they get a fake screenshot. They got nothing.
Tom. I love Tom. He gets fired up.
He does, dude.
If the O'Keefes are still with them after
There you go.
let's see the motion.
Yeah!
Oh, look at him. He can stay up in there.
Is that Peter Murphy?
Retired cannon cop Peter Murphy.
Yeah, Peter Murphy.
Nice. I love that they all cheered for him when he came out. I love it.
I met him. At
Yeah!
Very nice. I'm Karen. Keep your head up high.
We're gonna talk. They're gonna talk. You guys think we're gonna talk?
Hopefully. Nope.
No comment.
No comment.
Great job, Tom.
Yeah.
They have
Good job,
nothing- their
Tom.
work
Go,
is done.
Tom. Go, go.
There's nothing left for them to say.
Tom CPU, everybody getting that footage. Make sure to sub up.
Yes, absolutely. Keep your head up high, Karen. A lot of good things happened in court for you today.
Yes, they did. Yes, they did.
A lot of great things.
Nice job, nice job.
This is fantastic.
Oh, he's talking.
No comment? Are they giving any comments?
No, he's talking a little bit.
Oh yeah.
Nope.
Oh, shut up, Grant.
Oh God, brown finger. Brown finger.
Good job, guys. We're all proud of you. You did great job today. Great job.
You say take the plea?
Take the plea.
Imagine that. Come on. He's just like not a serious person. This isn't good. Stop it.
You can't like this. I mean,
What'd
he
you do
makes
ask?
things up out of thin air.
Yeah.
Like it's fascinating.
Just like his mother. Like they're just
Right. It's
not
right.
serious people.
You notice that they've shortened the walk now. They used to go all the way to the other side of the building. Now they're just parking on that side so they can get in and out really quick
Yeah.
because the trolls.
Oh my gosh.
This is the most insane shit ever.
Somebody messaged me and said, if anything, the phone call between Higgins and Albert suggests
I mean,
Right there.
Higgins was checking to see if John was
Right
okay.
there.
I don't think it says that. I don't think that. They knew he was
dude.
dead.
The phone call between Higgins and Albert right before
Yeah.
the
222.
222 search.
Is that 222?
Everybody just jumped in front.
That can't be a coincidence.
Jennifer
222.
Copeland, Jennifer Copeland said, David says about what the FBI confirmed. Consider the source. They have lied and misled throughout. And they will continue to do
I'm
so.
like, can you just
They're getting paid hundreds of thousands of dollars and they made up an entire conspiracy.
It
It does not surprise me they are spouting this. When I see a cast report that says so, I will believe it. They're just like, I don't believe the results. They just must be lying about the results of the federal investigation.
So
That's
she
it.
doesn't believe her own people. The organization that she worked for, she doesn't believe them.
Or she's saying that, like,
Okay.
result that I don't know. Like, she's saying that they're lying about what the FBI actually said. Right. And then about me, they go,
Have a good day.
she says, he was forced to leave his teaching job long ago.
Have a
False.
great day.
He then became a
Seeing you.
blogger. He's charged with 18 felony counts
We're
right now.
worried
He
about
just
you.
got out of jail for a domestic
Don't worry.
violence
I was-
incident.
I was-
Wrong.
You
Wrong.
weren't here,
You
but
libel.
wrong,
And
right.
keep running your
Everybody-
fucking mouth, Jen.
Stop. I'm
Keep
scaring me.
keep
all right?
posting falsehoods about me, Jennifer.
Okay. Just
Keep
long as
doing
it's
it.
all right.
Wow, dude. She's
Keep
mad, dude. She's on
Keep doing
fire
it.
too.
Keep about
Man.
to
Like,
lose
Their own
yeah.
people
Libel is.
confirmed it.
Just about you, you got
Keep
nothing.
it up. Keep it up.
Wow. And then she says, look for more charges in the future. Yeah, like what? Let's see. What are they? You fucking lying piece of shit.
I'm going to
Oh,
be
man.
reading her words off of an affidavit one day on my live stream.
No.
Right.
It's fascinating.
Yeah. So I think that's about it from them, right? So we can put that. I'll just mute that. So yeah, man. Any takeaways you guys have on this?
Yeah, big bombshells today. I think Jackson Yannetti were well prepared, well prepared, and I think that they knew going in that like the thing that I thought was really great about it is that they didn't think that they were going to get a time limit to it, which is bullshit. I mean, you put time limits on people's testimony. Never even heard that before. But I think it was great that it didn't rattle Jackson in the moment. He readjusted well, and I think he got a lot of points in that memo that he got over to Bev. The most important things out there, we've talked about this a bunch of times. The independent investigation by a federal investigator with 3 PhDs confirmed that Karen Reed's SUV did not strike John O'Keefe, and there's no way those injuries could have been done to John O'Keefe. And then we hear about the either text messages or phone calls 5 minutes before Jen McCabe's 227, and that's all confirmed by the Fed. So I think it's crazy that the Commonwealth and Lally and the DA's office is going to continue to push this forward. I think it's an embarrassment to the Commonwealth. This should be taken on advisement. And the next time that this goes into court, Karen Reed should be dismissed and free.
Absolutely.
I agree.
Let me just read some turtle chats here. Actually, why don't I? Are you guys? I'm just thank you guys for coming on. I don't want to bore you with the turtle chats or whatever, but I really appreciate you guys joining me with this fucking awesome stream. I'm just going to read some turtle chats here before we close this out. But
Real quick before you read chats, if it wasn't for you, okay, and I want to just make sure, if it wasn't for you, none of us would be here. And you have done such amazing work and sacrifice for everything that you've done. You sacrificed yourself to go to jail. Never heard of a journalist in my surroundings ever doing that. So thank you for everything that you have done. It's been an honor to share the stage with you, and it's been an honor to cover this case along with the Glairer and every other live streamer that does this, because you were right. You're right. You have exposed and put everything out there on the record, and you've been 100% correct all the way. So thank you. I appreciate you, man.
Thanks, man. It's
Yeah, I got to agree with all that. As well as, and I've been the timing of this for me, I managed to jump on this case and start really looking into it right when you got charged, right before you got charged. And so looking into that in real time and seeing you were clearly being railroaded, clearly.
Mm-hmm.
So, and then going into when you were actually jailed, and then hearing all of this, I'm like, I can't wait to see what comes next. I can't wait to see what you choose to do moving forward, because you have every reason to be infuriated. I mean, it's basically you've been vindicated federally, basically, here today.
It's a lot, man. It's just like the last 5 months of my life have been very difficult. Like,
right,
it's getting arrested in my driveway, charged, having bail set. Then the trauma I was put through on December 23rd and 24th, and then a lie that's made up to have bail revoked on bail that should have been issued in the first place, that we now know. And then to just have some corrupt judge, Paul McCollum, revoke my bail for a period of time that he can't even legally do it for. And he had to get reprimanded by the SJC for that. It's just a lot, man. And now that they want to send me back because the plant that they used, the angry ex-girlfriend who got dumped, they didn't bring her out today. They used her to have me charged. They used her as a plant. And then they used her on February 26th to try to have my bail revoked. And they're going to try to send me back to jail in 2 days. And it's a lot.
And that makes me think, because you got court on Thursday and you expected, you've heard you say a few times that you expected that they're going to try to send you back on Thursday. But I mean, after what we've heard today, I mean, can we expect Bradel to bring forward what we've heard today? I mean, that's got to have some positive effect on your hearing on Thursday for you. It has to hold some kind of weight. Hopefully, I would imagine so. I'm just thinking out loud here,
and she contacted me yesterday again, and we'll talk about that later.
Wow. Jesus.
Well, TB, just keep in mind anything going forward until there's completion of all of this. We're all here to help you, so keep that in mind.
Well, thank you.
We're here for you, man.
I appreciate that, guys. It's just I know I should be happy right now, but it's just a lot to take in. A lot after all that. It's just like, wow.
No, I can't even begin to imagine what you should be feeling or what you are feeling. Or, I mean, to me, you're justified in feeling however you just feel, because that was the craziest shit. Just everything. Every single time that you accused someone of being shady and uncovered evidence, the independent federal investigation justified this. They justified it. I can't imagine what you're going through right now. You did 2 months out of your life, and you sat
2 months
there
out of my life, and just the prior 2 months before that, just having these charges hang over your head, when you Google you now, like it just comes up as you're like an intimidator, you're this witness intimidation guy, like you're a criminal. Like that's how people who don't know me perceive me when they that haven't read the charging documents, they don't watch YouTube streams. That's the way the public perceives it. And it's all a lie. Everything was a lie. Nothing I did was illegal. And all of my peaceful protests were justified by the FBI investigation and what it revealed. And it's a lot, man. It's fucking a lot. So, but anyway, I'm gonna go now, but I appreciate it. I'm just gonna read some more turtle chats, but thank you, gentlemen, for coming on, and we'll do this again sometime.
Awesome.
Hey, thanks for having us, man. Appreciate it.
Thanks, TB. Appreciate it.
So let me just read some more turtle chats. Want to make sure I get these all. Jay Stark sends $5 and says, Big Dick Jackson slapping them with just the tip. He gave him more than just the tip today. He gave him the whole thing. Kristen sends $25, says, thank you so much for shining light on the truth for Karen and John. It's my pleasure. You know, I feel like today was a vindicating day. Thank you, Kristen. Jody sends $25, says, Yannetti is the best. I met him a few weeks ago at a restaurant. I asked him to shake his hand and he obliged. I told him it was like meeting a rock star. Today he was awesome. Justice for all. Yeah, David Yannetti is a good guy and he's a great attorney. So thank you very much, Jody. Crystal sends $10, says, thank you, gentlemen, for making my last chemo session much more enjoyable. Wow. I am glad to help. God bless you there. God bless you there, Crystal. Kyle V sends $25 and says, where are you at, Hot Dog Water? No, for real. I see dollar signs for Turtle Boy. And this right here is the Dream Stream team. I like that one, the Dream Stream team. Thank you, Kyle. Mindy sends $25, says, the light will always shine on darkness. Karen will be freed and the real justice for Officer O'Keefe will come to those who did this to him. God bless you, Aiden. Thank you very much, Mindy. Alex sends $10, says, W yesterday, W today. Let's keep that energy and pray for a three-peat on Thursday. I was thinking the same thing after yesterday's win. I'm like, maybe this is a sign of more big things to come. Absolutely. Of a good week to come. Mr. Meathook sends $10, says, exhale, Aiden. Exhale, bro. It's hard, man. It's fucking hard. The shit I've been through. It's hard. The Spectre Report sends $5, says, 3 things. Lally came in looking ready. Left looking defeated. Number 2, grand juries don't hear everything and exculpatory evidence is never presented to them. Don't rely on their decision to form an opinion. Number 3, you almost never hear attorneys calling the other ones liars. Yannetti did this and it should be noticed. Absolutely. The Spectre Report. Also, I think I got a couple cash apps here. One from Stephanie sends $25 and says, let's go. Looking great. Thank you, Stephanie. I appreciate that. And Tammy sends $10 and says, thank you for being you and all you do. Free Karen Reed. Absolutely. So, hey, look, I love you guys so much. I feel vindicated beyond reproach today. It's a lot. It's a lot. So it's a lot to take in. I'm going to rewatch it. And tonight on Howie called me during the stream. I'll be on there at 6:08. And then I'll be on, obviously be doing my show at 9 p.m. So thank you guys all from the bottom of my heart. And we will see you guys a little later. Bye. Peace.